Good morning, Stephen. This is an interview with Stephen Gowland. I'm very grateful for you coming over to York to conduct this interview, and I appreciate you're very busy. By way of introduction, Stephen is a dual qualified solicitor and CILEx fellow. He is also a qualified mediator, and he has since around 2016 been on the Police and Medical Conduct Tribunal. So he's also a past president of CILEx, and I think that was about 10 years ago, wasn't it, Stephen?
Yeah, 2013 to 2014 it was, yes.
Right, yes. So, Stephen, it would be good if you could just talk to us a little bit about your involvement with CILEx and what you've actually... there's been a lot achieved, and I know that you have been a main part of those achievements.
Yeah, well, I started, as a lot of people do, on an employment training scheme back in 1989, working and studying at the same time and getting the qualification. Later on, around about 2000 I think it was, I became involved in the relaunch of the Newcastle branch, and I chaired that branch for quite a number of years and was on the committee for 16 years in total. And around 2004 I joined the CILEx National Council, in effect the board that governs CILEx, and became national president in 2013. And during my time on the board, we as an organisation achieved quite a lot. We achieved the right for members to be partners in firms, members to be judges, independent practice rights for members, which meant they could set up their own law firms without solicitors, and also we gained the Royal Charter as well, which was a big sort of application that had to be done, and a very complex application, but which we thought would benefit our members, as in increase their standing in the legal community.
Yeah, I think that touches a little bit as well on the history of CILEx from what you say. I mean, I myself was on the CILEx Council 2015 to 2017, and I know, well, at that time we'd already got the charter, but when I started out with my training, we were ILEX. It would be useful to know a little bit more about the structure of CILEx as it is now, and particularly in terms of the bylaws. I'm not sure whether or not well, I do know actually that you would be able to explain a little bit more about the bylaws, because I know that a lot of fellows don't understand the structure of CILEx and how or where the members' rights come from as a member of the Chartered Institute of Legal Executives.
Well, the bylaws and the Royal Charter are really sort of one document now, and basically what that is a contract between the members and the organisation, and obviously the members pay their fees to the organisation for representation and regulation, and the bylaws set out the relationship between the members and the organisation, and give certain rights to the members in relation to voting, in relation to being able to actually change the bylaws if the members want to make changes to those bylaws, and the ability for members to call special general meetings or SGMs if they think that something needs addressing within the organisation.
Yes, you mentioned about SGMs. I know that there have been requests for SGMs by members. Are you able to explain a little bit more about the SGMs that the organisation has already had, or?
Yeah, certainly. I think the first thing with SGMs, they are quite rare with organisations generally. I don't remember, there weren't any during my time on the CILEx sort of governing council, which was between 2004 and 2014. I don't recall any before then. The first one I recall was in 2016, which concerned the departure, or the disappearance almost, of the then chief exec and the then president, who seemed to have just disappeared entirely from public view. The members were quite concerned, and obviously a number of members, along with myself, had heard various things about what was going on. CILEx had stayed entirely silent, no communication with the members about this at all. So we called a special general meeting to inquire into that, and it came to light a few months after that unfortunately at that special general meeting, CILEx misled members in as to what the reasons were for the chief executive and the then president leaving the organisation. And that meeting was overseen by the person who's now our current chief executive. So that really concerned me at the time. And there were, I understand there were non-disclosure agreements in place with the then president and then chief executive. And I understand entirely about the legal obligations that CILEx would have had. But those legal obligations did not lead them to necessarily have to mislead members. Members could have been told something that was truthful without CILEx breaching their obligations under any agreement. So that was the first SGM that I recall, and then in recent months there's been at least a couple more requested. CILEx unfortunately have the first one that was requested ignored it, or said they were ignoring it because there wasn't sufficient numbers who'd requested it, because you need 50 fellows to request an SGM. Yet then they still put out a written response to the matters that were raised. Move forward a couple of months to November of 2023, a further request which I was involved in this time was put in. We had the signatures in effect, or the confirmation of 64 fellows to call this SGM, and we suggested making various changes to the bylaws. CILEx responded to that by basically answering the previous SGM yet again. They did not respond to the SGM that we put in November whatsoever, but they did not allow members to debate or vote on any changes to regulation. One thing I must mention about that, they had an issue with one of the changes we wanted, which was to allow members to have a vote on whether we should be regulated by the SRA, and I entirely accept that any such vote CILEx would not be able to take account of, because they've got to act in the public interest under the Royal Charter. However, the vast majority of the changes to the bylaws that we suggested or requested in that SGM notice were nothing to do with regulation, yet CILEx completely ignored them, which is very worrying for a professional organisation to ignore its members making lawful requests under the bylaws as we're entitled to.
Yeah, you've mentioned about the bylaws being part of and joined in with the charter. I mean, I remember that when we got the charter, it was such a big thing. Now, from what I understand, the Law Society also have a charter. And again, you mentioned the Legal Services Act. My understanding of the Legal Services Act is that, thinking about the three main arms of the legal profession being the Bar Council, the Law Society, and CILEx, the Chartered Institute of the Legal Executives. My understanding is, and I'm sure you'll correct me if I'm wrong on this, is that the Legal Services Act basically made those three main organisations the approved regulators, and that they gave them, the Legal Services Act gave those powers to them to delegate the regulation, so that the Law Society, CILEx and the Bar Council could be the representative arm for their members. And so the approved regulators then delegated, CILEx delegated to CILEx regulation, Law Society delegated to the SRA, and the Bar Council delegated to the Bar Standards Board. That's correct, isn't it?
Yeah, that's right. I mean, I was actually on CILEx Council when, first of all, when the Legal Services Act came into force, which was a good number of years before the Royal Charter. Basically, that meant we did have to separate off regulatory function from membership and representative function, and delegate that to what is now CILEx regulation. This, it wasn't a problem. We still, as a representative organisation, continued to represent the members, continued to gain additional rights for members. We were very transparent and open as to what we were doing. It didn't affect the day-to-day business of the CILEx Council whatsoever. So yeah, it's very clear though in the Legal Services Act that although CILEx, for example, maintains the status of approved regulator and will have to delegate that regulation to CILEx regulation, it's very clear in the Legal Services Act that they cannot allow that approved regulator status to interfere with their representative function. So it's very clear the meaning of the Act and the meaning of the what this LSB issue called the internal governance rules are very clear that representative function is still retained by CILEx, and they can't allow their regulatory function to interfere with that. So it's basically, I suppose, a type of safety valve, or to actually make sure that the bodies that are now mainly representative, like CILEx, still continue to be representative and don't get tied up in regulatory matters. Something which when I was there from 2004 to 2014, it's a very easy thing to do. And we've seen recently, I'm sure people have seen how vociferous the Law Society is, and how they stand up for their members and how they represent them very well, in my opinion. And recently at a meeting, our chief exec of CILEx said that CILEx can't act in the same way as the Law Society because of our Royal Charter, and that's just entirely incorrect. Because as you said, the Law Society have had a Royal Charter. They've actually had their Royal Charter since 1845. So the Royal Charter does not stop a representative body from still performing its representative functions.
Yes, and just picking up, you mentioned about council. I was on council 2015 to 2017 as an elected by the members, council member to represent interests on that board. Now we now have the different boards as opposed to CILEx elected council members. Can you explain a little bit about what their function is in terms of their non-executive directors? What exactly is the purpose of what used to be the council members and now the professional boards?
Yeah, it's a non-exec. I mean, in effect, the CILEx boards now are made up of fellows and non-lawyers as well, which is quite common across professional organisations, and that isn't a problem for me at all. But the duties of all of those non-exec directors are very, very clear, and it's to challenge the executive, to robustly challenge, robustly debate, robustly examine proposals that come from the executive, and certainly not to just vote yes on everything. Certainly in my time we had some very robust debates around the table, very different opinions about way forward, but that is the sign of a healthy organisation, an organisation that is willing to be held accountable by its non-exec directors and its members ultimately. And the duties there are something that anybody sitting on any sort of board needs to be acutely aware of, because ultimately directors have responsibilities, they have liability as well if things go wrong in an organisation. And I think recently it's perhaps been in the public eye a little bit with the post office scandal, because obviously we've all no doubt read in the press and seen the drama about what the executive, particularly the chief executive there, were doing, and what was the result of that. And what has, a little bit of it came out, not much because it hasn't been the main focus, but obviously there's been a little bit of commentary from people about, well, the non-exec directors on that post office board, what did they do? What did they challenge the executive as to the direction the executive was taking? And if not, why not? Because if they had challenged correctly and robustly, then it may well have been, perhaps, that some of these horrendous things that happened in the post office scandal may not have happened. And my worry is, for any professional organisation, CILEx included, if the non-exec directors do not do that, then there's a danger of the organisation going in the wrong direction, the wrong things happening to the organisation. Obviously, the post office is perhaps an extreme example, but it gives an indication of what can go wrong in an organisation if the non-exec directors do not fulfil their role correctly.
Yes. And I think the other thing as well, in terms of holding the executive board to account, and in fact the current professional board, members have the rights under the bylaws to call an SGM, which is, you've covered part of that. You mentioned about the SGM's 2023, and I know that the actual requests that were made on those included questions regarding financial access to financial records, accounts, as a result of, I understand it being from the AGM where there were anomalies that were raised prior to the AGM as well, regarding the practicing certificates, fees, and also there were some concerns about losses that were in the accounts. Can you just explain a little bit more about what that was?
Yeah, I mean, it's myself and a number of other members that I know actually made requests, because again, in the bylaws, it enables any member to have a full copy of the accounts and to have the accounting records. And obviously anybody that's been involved in running a business will know that accounting records are invoices, payment receipts, all of the documents that in effect make up your income and expenditure. So everyone knows what accounting records are. Both myself and everybody else who applied for these accounting records and accounts have been told, in effect, we can't have them. This is against the background and the reason that myself and others requested these of CILEx in the last financial year posting a £3.6 million loss, which is horrendous, and having a £1.95 million overdraft facility. And given the relatively small financial reserves that CILEx as an organisation has, those losses are a massive proportion of their reserves, and clearly the organisation financially isn't doing well, and hence the reason for requesting these accounts and accounting records. In fact, I actually at a roadshow requested these face-to-face from the chief executive, who promised to give them to me, and in fact even said if I wanted to come down and sit with the chief financial officer and go through the accounting records. And I said, well, there was no need for that, and I said I only really need the documents around these specific areas. Again, I was promised copies of those. That promise was reneged upon, and obviously when the formal request went in, we were told we couldn't have them, which again puts up warning flags, because you start to think, well, if the organisation that's posted such big losses is hiding the actual documentation that shows why they've made those losses, then why is that? That's quite worrying, and again should be something that all members are concerned about, and certainly the non-exec directors on the board should be asking serious questions about this.
Thank you. So we've got some current proposals from CILEx, and it really relates mainly to regulation. Now, I think that a lot of members are not clear on what the difference is in terms of the regulation and the membership side of CILEx, the same for the Law Society and the same for the Bar Council.
Well, obviously CILEx, we delegate to CILEx regulation. CILEx, the organisation, delegates regulatory function to CILEx regulation. So basically, anything to do with the regulation of you as a lawyer or as a person who's trained to be a lawyer is dealt with by CILEx regulation, whereas CILEx, the representative body, is there to represent members and represent our interests, and because of the Royal Charter Act, in the public interest, which again, same position as the Law Society. So regulatory wise, it's very simple, you know, that if you needed permission to set up your own business, or you have to log your CPD, or you get into trouble for some reason, it goes via CILEx regulation, not the representative body. That's the reason why regulation and membership were split, so there wouldn't be any conflict between those two aspects. And obviously the current proposal from CILEx is to change the regulator of legal executives to the Solicitors Regulation Authority. And my worry there is that at the moment there are around 200,000 solicitors. There's about 17,000 CILEx members, even with the new paralegal members who have joined. And we'd be very small fish in a very large pond. And I think back to the matters that I dealt with when I was on the CILEx board, and the things we achieved for members, like the right to be judges, partners, set up their own business. Often there was resistance from the Law Society on these additional rights for members. And my worry is, going forwards, if CILEx determine that members need X, Y or Z extra rights, and have to get their regulator on board for that, if the Law Society objects to these changes and sees it as a way of something that perhaps is eroding the sort of solicitor's qualification, then who do you think the SRA is going to listen to? The membership body that has 200,000 members regulated by it, or the membership body that has 17,000 members regulated by it? And I seriously worry that in that situation the Law Society would have so much influence over the SRA that CILEx members would be in effect left in limbo, and this building on our rights of members that we've done over the years will suddenly cease.
It's a very interesting point that you make there regarding the Law Society about their influence over the SRA, because my understanding is that CILEx, as the approved regulator, have delegated it to CILEx regulation. The Law Society have delegated it to the SRA, and the Bar Council have delegated to the Bar Standards Board. So effectively, what CILEx is doing, trying to remove their delegated regulator, could be done by the Law Society and could be done by the Bar Council, because it's the same setup under the Legal Services Act. I'm correct in my understanding of that?
Yeah, no, that's absolutely right. The organisations can delegate to any organisation. It'd be a rather bizarre situation, wouldn't it? You know, if you had CILEx members regulated by the Solicitors Regulation Authority, solicitors regulated by the Bar Standards Board, it'd be rather bizarre. But yeah, absolutely, under the law, yeah, it is possible to delegate to a different organisation. It is interesting, the point about the Law Society, and I think they said something similar on their first communications, saying that they set the SRA up purely to regulate solicitors, and that's the way the articles, etc., are written, and that's the way the SRA is set up. So it is an interesting hurdle that any change in regulator by CILEx would have to get over. CILEx's argument is that their changes, or their proposed changes to titles and such like, and change of regulator is in the public interest and will benefit the public. And I think, as the Law Society and many others who've responded to the consultation have pointed out, that just isn't supported by evidence that CILEx have produced. In my opinion, creating new titles, having CILEx members regulated by an organisation that regulates solicitors, I don't think it will benefit the public. I think it'll cause confusion to the public. The public don't need more titles. If anything, things need to be simplified, not overcomplicated. So I think it isn't in the public interest to create new titles, to change regulators. There's no tangible benefit that I've seen in the evidence that's been published by CILEx, and that's been, again, picked up quite well in the Law Society response in relation to that. Obviously, they're governed by the same rules as CILEx. They're governed by the Legal Services Act, by the internal governance rules, and they are able to represent their members. And in fact, a good example of Law Society members using their powers under the Law Society bylaws and rules is a couple of years ago, the Law Society made quite significant changes to their bylaws and rules in relation to the Law Society Council members. Their term used to be indefinite if they got re-elected every, I think, 4 years. But now, following a resolution by members, which was voted on at a general meeting, the Law Society has now restricted council members to a maximum of a 12-year term. So this is by way of contrast to the way that CILEx dealt with the special general meeting request from members recently in November, whereby changes that didn't relate to regulation, similar to the Law Society, changes that were made were completely ignored, weren't allowed to be debated, weren't voted on, and in effect CILEx just ignored its members' concerns, which is extremely worrying and perhaps indicative of an organisation that doesn't want to be held to account for its actions.
You clearly have a lot of background knowledge and experience with CILEx and the regulatory and the membership, and I hope that members will find this interview very useful to understand what is happening today in terms of proposed changes and the implications for chartered legal executives and the membership. I hope that everybody has been able to learn something from this interview, and if there are any questions that anyone who watches this film have, then I'm sure that Stephen, you will be happy for them to contact you direct, and I would also be happy for anyone to raise any issues direct with me regarding any of the content. I'm very grateful for you coming along to York today, and it's been very useful to have a chat with you, and for us to hopefully continue to help the membership. And again, thank you very much for your time, Stephen. It's been very useful talking to you.
Thank you.
Thank you.